I'm Lynette Tubbs-Verlanig, Fiduciary Trust Officer with the Office of Special Trustee for American Indians, the Northern Cheyenne Field Office and Rocky Mountain Field Office.
And I'm Carrie Huggs, Fiduciary Trust Officer for Crow Indian Agency. Roles and responsibilities of the Office of Special Trustee, referred to as OST, provides financial management of fiduciary trust. OST is responsible for coordinating reform efforts to improve overall trust asset management and beneficiary services. The purpose of OST is to provide oversight, reform, and coordination of the policies, procedures, systems, and practices used by various agencies to manage Indian trust assets. This effort is imperative in meeting DOI's goal of its responsibilities to American Indians and Alaska Natives. The overall goal of OST is to protect and preserve Indian trust assets and collect and accurately account for income due to beneficiaries. OST will refer individual Indian account holders as well as tribes as their beneficiaries versus clients. To obtain agreement with all tribal and individual Indian account holders of the balances in their trust accounts in a manner that is fair to both the Indian community and the general public, does not impair or impede reform efforts, and does not result in reductions in Indian programs, and to provide timely and responsive customer services to their account holders. OST's vision statement is to be the premier public service organization dedicated to the Indian Fiduciary Trust. Our mission statement is to honor our trust responsibilities by incorporating a beneficiary focus and participation while providing superior stewardship of trust assets. Our values is to consistently and effectively provide quality service to our beneficiaries while displaying integrity in our actions, excellence in our work, and mutual respect and teamwork in our interactions. Our organization includes appraisals of Indian trust property, historical trust accounting, the reporting of accounting to beneficiaries to fulfill the Department's fiduciary duty per American Indian Trust Fund Management Reform Act of 1994, program management, which includes Office of Risk Management, Trust Review and Audit, and the Office of Trust Records. The Trust Services operates and controls accounting activities, ensuring compliance with policies and procedures. Lastly, Field Operations works directly with beneficiaries through 52 fiduciary trust officers across Indian country. Services include estate planning, financial literacy, and we serve as liaisons for the beneficiary regarding their trust issues as well as maintaining IIM and tribal accounts. The local field office views themselves as a one-stop shop for beneficiaries on their simple or complex issues concerning their trust land assets. Account holders are able to call in or visit the office to update their IIM account information. Beneficiary services provided by OST encompasses all Indian country. If a beneficiary lives on or near a different reservation, they are able to visit the local OST office to address their trust issues or receive services. The FTO will contact other locations or agencies, Honor, who manage the reporting of minerals, BIA, OHA, who probate Indian estates, or other OST offices to resolve complex issues. We educate the beneficiaries regarding their land title holdings, what fractionated interest is, how it is acquired, where the land is located, income derived to the extent of estate planning by utilizing their asset statements or providing ITI, individual tribal interest reports, landowner income reports, or title status reports. OST will explain the probate process and timeframes to beneficiaries so they are able to understand how trust interest is conveyed and funds are distributed. The best opportunity for OST to reach out to a new landowner is right after they inherit undivided interest through the probate process. From there, we're able to encourage direct deposit and provide our contact information for future services regarding the management of their IIM or land interest. FTOs are able to further expound on their trust interests regarding the lease processes and other encumbrances tied to their land, so the beneficiaries are better able to understand land management. One of our primary focuses is to locate whereabouts unknown. WAU is an individual with an IIM account without a valid or current mailing address. Rocky Mountain Region alone currently holds over $5 million in 4,522 WAU accounts. We also provide financial literacy to groups or individually to empower or positively impact Indian country. The roles and responsibilities for the BIA. The Bureau of Indian Affairs carries out the trust responsibilities associated with the management and protection of trust and restricted lands, natural resources, and real estate services. Programs included are real estate services. They are responsible for acquisition, disposal, tenure, rights of way, permits, leasing, and sales. Land Titles and Records oversees policy, development, deployment, and implementation of the title portion of the trust assets and accounting system, and oversees the administration and maintenance of title documents, document certification, title research and examination, and the determination of legal title for federal Indian trust or restricted lands. LTRO offices are centrally located. Billing serves as Rocky Mountain Regions. The Probate Division exercises program oversight and provides planning and scheduling of Bureau probate and assisted activities with the Office of Hearing and Appeals. Most local BIA probate offices maintain the original allotment case files. Natural Resources is responsible for the direction and guidance of all activities related to the planning, management, conservation, development, and utilization of soil and water. Farmland, rangeland, fish and wildlife resources, and endangered species. This division is required to evaluate natural resource damage assessment and restoration programs. Forestry and Fire Management is responsible for providing coordination, management, planning, and oversight, and monitoring of activities related to the development, enhancement, and protection of trust forest resources. Human Services is responsible for supervising all minor children's IIM account as well as adults in need of financial assistance and adult non-commenters. BIA and OST carry out the same fiduciary trust responsibilities for Indian trusts. Let's move on to the landowner's responsibility. The landowner should understand what fractionated interest is. Some individuals perceive that they own the whole tract and not the undivided interest. They should be familiar with the land interests they hold trust title to. Some individuals might want to give according to how they inherit. In order to differentiate the interests they receive, they should be able to distinguish by the document number listed on their ITI report. They should know how the interest they hold is titled, ownership and interest type. The ITI report will indicate NA for all, beneficial and title, meaning a clear title. Otherwise, if a different letter is listed on the report, this would indicate a special interest type. J is for joint tenancy, D is for a dower, or a P for life estate with rights of survivorship. Fee interest is not listed on an ITI. They should know if a tract holds a home site or a burial site. Not all home sites are recorded by the BIA. It helps to know the income generated from the tract. This is provided on the landowner income report. Some elders still reference the allotment name instead of the tract allotment number. The original allotment names are listed on the ITI, which can be referenced. The landowners should come to their appointments prepared. They should already know who they are devising their real and personal property to. They should know the legal name of the heirs, know their date of birth, and enrollment numbers of the heirs are helpful but not required. The landowner should be able to list all their children, including adopted in or out, deceased, cultural custom adoptions, and throwaways. It would be necessary to counsel in a culturally sensitive manner on the reason why all children should be listed on a will even though they may not be giving any property to that individual. I have covered the responsibilities of OST, BIA, and the landowners. Lynette Verlanik will provide more information regarding fractionation and explaining further on the reports required for estate planning.
First, it is important to understand fractionation and how it affects Indian country. For the Rocky Mountain region, the Department of Interior manages surface acres for tribal and Indian trust land in the amount of 6.4 million acres. This is divided tribally 3.7 acres and allotted individual surface acres 2.7 million acres. The Department of Interior also manages mineral leases in the amount of 7.5 million acres. The tribal mineral acres are 5.3 million acres, while the allotted mineral acres are 2.2 million. There are 52,676 unique individual undivided interests holders in the Rocky Mountain region. The Rocky Mountain region consists of all of the Montana Indian tribes, excluding the Salish Kootenai, and includes the Wyoming Wind River Reservation. The breakdown of the unique individual undivided interests for each reservation is Blackfeet is 8,076 undivided interest holders. Wind River is 7,951 unique undivided interest holders. Fort Peck is 5,991 unique individual holders. Crow is 4,410 unique individual holders. Fort Belknap is 3,598 unique undivided interest holders, and Northern Cheyenne Agency holds 2,731 unique undivided interests. So what is fractionation? Fractionation is an increasing number of owners for a land parcel with each passing generation. When the reservations were allotted originally with the executive orders, the original allottee was provided an allotment which allowed them to have 100% ownership over that allotment acreage. When the original allottee passed away, the ownership was and has continued to be distributed among their heirs as an undivided interest, increasing the number of owners per land allotment. It is important for the Indian landowner to think of the undivided interests versus acres. The landowner does not own a specific acreage. They own an undivided interest. So the way we explain it to the individual landowner is that they would go pick up a handful of soil on the allotment that they own an undivided interest with, and they don't own any specific granule. They own their undivided interest in the entire handful of soil that they've picked up, along with the other undivided interest holders. It is extremely important that they think of it as undivided interest versus acreage. On slide 9, the inheritance of individual undivided interests by fractional values through 6 generations is depicted. This is the picture of what fractionation has done in Indian country. In the first generation, you see the original allottee who has received the original allotment at 100% ownership. This slide depicts that there will be no surviving spouse, and only the children are the ones that are going to inherit through this, through the passing of the original allottee. As you see, each of the 3 children received a 1/3 undivided interest. They didn't receive specific acreage. They each received a 1/3 or a 33.3% interest in that allotment. As you see, when it goes down to the 3rd generation, when the middle child of the 2nd generation passes away, the 3rd generation receives a 1/3 of a 1/3 share, or 1/9 undivided interest. And as we continue through the passing of the generations, when we get to the 6th generation, the individuals inheriting receive a 1/432 share. This means that these individuals shared a 1/3 of a 1/4 of a 1/4 of a 1/3 of a 1/3 share of an undivided interest. So as you can see, this example shows the significance of fractionation throughout Indian country and why estate planning is so important. So where does the Indian landowner obtain the necessary documentation to start the preparation for estate planning? They would go to the Office of the Special Trustee for American Indians, OST, or the Bureau of Indian Affairs, BIA. And in that, they would request an individual tribal interest report or an ITI report. This report is going to tell them their beneficial or title interest, their ownership type, whether it's a surface, mineral, or both. We can also provide to them estate planning options, explain how to read their reports, and determine whether or not there's burial sites, home site leases on any of the allotments. It's important for them to know that if the lease, a home site lease or burial site lease is not recorded, that they will need to do further research with the Bureau of Indian Affairs by obtaining aerial maps to help them identify which allotment number the burial site or the home site lease is on. In addition, it's important for the individual to know if they have a tribal home site lease or if their home site lease is on an allotted land. If it's a tribal home site lease, they're not going to be able to pass that home site through their will. So if the home site lease is on an allotted, individually loaned tract, the individual can pass their interest in the home site through their will. So let's discuss how to read the ITI report. This is going to be the best information that the individual can obtain in order to prepare for their estate planning meeting and to determine how they're going to devise their assets. So once the individual obtains the ITI report, this is going to be the information that will help them to prepare for their estate planning meeting with their preparer. This report reflects all the Indian trust undivided interests that they hold throughout Indian country. This report will indicate where the land area code is. It will give you a prefix indicating whether it's a mineral, surface, or both. This particular prefix is very important. It will have an M if the minerals have been severed from the surface. It will have an S if it's the surface interest and the minerals have been severed. It will be blank if it's both surface and mineral. The next column indicating number is the original allotment number. This is very important for the individual to know, and when preparing their estate plan, they need to be able to specifically utilize the land area code, prefix, the number of the allotment, and any suffix that might be attached to it. A suffix usually happens if the land has been partitioned and will be indicated separately on the ITI report with the alpha character as the suffix.
Okay,
The next column, title plant, will indicate what Land Title Records Office manages and updates for that particular reservation. When you look, the land area code indicates Billings, Montana, and that Billings is the one that will handle all of the Rocky Mountain region. The next column over is land area, and that'll indicate where the land is located, which reservation. The column designated as resources will indicate if it's mineral only, surface only, or both mineral and surface. The next section down will indicate the legal description for the land. It'll tell you the section, township, range, county, and meridian, along with the legal description and the individual acres that are associated with the legal description. Below that is the total tract acres for the entire allotment. As we move further down the ITI report, you will see the columns that are under owner document. The type 1 will have an I for Indian, which indicates that this is in trust. The second column, OT, is ownership type, trust. The next one will be interest. The interest type can indicate all for both beneficial and for title, or it can indicate just life estate for a beneficial interest, or just title if they only own the land and don't receive the income. In addition, it will tell you if the ownership title is joint tenancy with rights of survivorship, or it will tell you if it's a dower interest. The next column over is the class. This will tell how the land was received, whether it was a trust patent, executive order, act of Congress, secretarial order, deed to trust. A deed to trust means that you either purchased the land or it was gifted to you. In addition, if it was received, if the undivided interest was received via probate or probate modification, it will be indicated here as the key reflects. The number column indicates what the recording document that transferred the title of the undivided interest was. If it's a probate, the first two letters of this number will indicate the city of the assigned law judge. In this example, TC indicates that this is the Twin Cities. The next three numbers and the one alpha indicates the law judge it was assigned to, and the last three numbers will indicate the year in which it was submitted to the law judge. The next column over will indicate the name in which the undivided interest was first acquired. As we go over across to the columns, it'll show the aggregated share. In this example, it shows 1 over 54 parts. In this example, it shows 1 over 54 parts, or an aggregate decimal of 0.0185, which means that this individual has an undivided interest of 1.85%. Again, we discourage individuals from referring to their undivided interest as acres. However, we did give you the conversion that you can take the surface interest only, divide your aggregate decimal by the total number of acres, and that will give an approximate acreage that the person owns. Again, we discourage you using this type of calculation as the individual owns their undivided interest in the entire acreage, not any specific acreage itself. So for the preparer, we have some helpful hints. Be direct. Clearly state the requirements for the appointment. Understand that most Native people are visual communicators. Thus, you may need to use a small explanation in order to get the answer to your question. An example of this would be that if you're asking how many children do you have, please list them all. You may have to explain to them that you need to know all the children they've had, living, deceased, adopted in, adopted out, legally through the court system, and any children that they've adopted out or in through Native custom. If you don't give a leading example, they may not provide to you all of the information that you're requiring. Remembering, you're providing the service. Therefore, the client must come prepared.
My name is Frances Scarry. I work with the Confederated Salish and Kootenai tribes. I'm the probate specialist there. I handle probates, estate planning, and will writing. CSKT is a compact tribe. In 1990, the Flathead tribe compacted the management of the Flathead Agency's Land Operations Branch from the BIA, eventually compacting approximately 90% of the BIA functions. In 2002, the Tribal Council created a new department, Tribal Lands, which includes 4 main programs: permitting and leasing, land planning, land services, and the first tribally managed LTRO in the nation. Current will writing has been approved by the Tribal Council for the following types of cases. If the person has land only on the Flathead Reservation, meaning they cannot own on another reservation, that they have no fee properties, and if they have home sites that need to be probated. CSKT is an IRA tribe. That means that trust land cannot be transferred as fee property in a written will. Information that we can provide to assist the client in making a will: we can provide a copy of the ITI report to them, explaining how to read that report, And since we have our own title plant on site, we're able to pull these documents quickly. We can provide income reports as well for their property ownerships. We look at each person's individual situation and present them with their options. Estate planning options can consist of options that present to the client what they can do in their lifetime, such as gift deeding and or retaining a life estate, selling to their chosen heir and or retaining a life estate if possible, selling and gift deeding to co-owners, or selling to the tribe itself, remembering that the tribe always has first option to purchase in all situations. Some items we may ask the client to provide to shorten the probate process would be copies of the marriage and or divorce information, copies of the spouse and the children's birth certificates, copies of death certificates if they apply, and copies of adoption records. Also copies of any name changes that may have occurred. As an added note, personal records are not necessary to produce the last will and testament, but desired information for the probate process only. We ask that this information be provided by the individual making the will because they would be the person more likely to access these records in their lifetime. Forms that we use: release of information forms if needed, a will intake form, which we ask to be left with the will when it's produced. And also CSKT provides a burial benefit to each of its enrolled members. Additional services that we provide, we give the client the option to retain the last will and testament for themselves or to store the document with our office. These documents are retained in a fireproof vault with limited access to assigned personnel only. Privacy of the document is our #1 concern. I was asked to address cultural approaches to the Indian client. One of the cultural customs that I have run into is the handshake. Some individuals do not shake hands with unfamiliar people, as well as some individuals do not apply pressure when shaking the hand. There can be signs that this is disrespect to them. I have found that letting the person lead the way is the best. Asking the tribal contact for the agency where the will is going to be used eventually, for any customs that may be necessary to be aware of for that area would be a very good idea for the person writing the will. Also, death can be a very taboo subject for many Native Americans. Use caution with the subject of predeceased heirs and with the fact that most Native Americans don't like to address burial whatsoever. Finally, ask if an interpreter is needed.